Okay, Michael J here. How you guys doing? Okay, we're going to start off with we're reviewing another videographer slash lawyer. Okay. Now, here's the byline on the video that we're going to present. It's called Chief Justice Roberts is Unfit to Serve. Okay, so the byline on this video that we're going to put forth is Chief Justice Roberts is unfit to serve. So what we've got here now is Mr. Rekieta Law himself, Mr. Nick Rekieta. So let's go to the live screen now, and let's see what he has to say.
Okay. It might be time for John Roberts to leave the Supreme Court. John, you've had a run. You've led the court. Okay. It might be time for John Roberts to leave the Supreme Court. John, you've had a run. You've led the court through some very interesting times. You've made some questionable decisions, but on
Whoops, I forgot to unmute my microphone. Okay, so what we're seeing is an opinion here from Mr. Rekieta of Nikita Law. And remember, this is an opinion, and I'm going to provide an opinion as well. There really is no right or wrong. This is just opinions, and let's see where it goes. So, Mr. Rekieta, take it away, sir.
balance, you've been pretty good on free speech. This decision is the opposite of that, and in light of everything, I think it's time maybe we part ways. But that's my opinion. Why does that matter? It doesn't. But I'm Nick Rekieta of Rekieta Law, a small...
Mr. Rekieta, yes, your opinion matters immensely. And we need a divergence of opinions, and you know I stress opinions, in order to derive some form of consensus. This we know, this is what we're striving for. This is how we get something that's fair and equitable for all, with the understanding that today's truths may no longer apply 30 days from now, all depending upon discovery of. So upon discovery, we might change our perspective, which in turn will change our perceptions. Okay, so I've rambled on enough. Let's go with Nick here now, see what he has to say.
A law firm in central Minnesota. I'm a lawyer and a legal and political commentator here on YouTube. If you like that type of stuff, hit the subscribe button and the notification bell so you don't miss anything. Today we're talking about John Roberts in this recent First Amendment case being the sole dissenting voice. An 8-1 ruling from the court with the one being an absolute lunatic. But it also goes to show where.
Hold on. The one lone dissenting opinion. How did he put that? Let's see how he put this.
Voice, an 8-1 ruling from the court, with the one being an absolute lunatic. But it.
Oh, the one being an absolute lunatic. Mr. Rekieta, is that not somewhat harsh, monsieur? What does Viva Frey have to say about this? Oh, la tabernacle. Anyway, I digress. I think I'm slightly overemphasizing an overemphasis on the part of the presenter of this video. Nonetheless, let's move forward.
It also goes to show where John Roberts is headed, and it is not in a place that is respecting the rights.
Hold on. This goes to show where John Roberts is headed. What crystal ball are you using there, Nick? You have no idea where it's going. You have an intuitive sense, and how accurate has it been up to this point in time? And really, being a lawyer, most things are fact-based, right? Right? So that's just another personal opinion presented by the videographer or the main character, main person of interest, pursuant to representations by Rekieta law. So let's go back to the video.
Of the individual, and that is the only type of justice that I want on the Supreme Court. One who recognizes that our rights, your rights, my rights, the rights of the people around us individually form the foundation of the United States. And
Not sure where he's going with the forms of the foundation of the United States. It doesn't matter where in the world you are. Free will and the right to express yourself is our inalienable right as human beings on this earth. It's got nothing to do with being exclusive to the United States of America. I want to make that clear. This is our exclusive divine right, no matter where in the world or the universe we are.
recognizing and respecting those rights has been critical to keeping the nation running for 250 years. That's the point of the Constitution. And if we don't have a Chief Justice who understands and recognizes that,
Constitution is open to interpretation by anybody at any time, past, present, or future.
maybe it's time to get a new Chief Justice. Not that I want Biden picking him, but I think it's going to take a little while to convince.
Hold on. What's Biden? Biden picks it. Republican president picks it. What does it matter? Now, if it does matter, we've got an issue here, and I'll tell you why. Because politicking and self-interest with politicking, with respect to the justice system, I have an issue with that. And that's influence. Politics should be one thing. Justice should be totally independent. And let me explain a little bit further. No political party should be picking justices. No executive branch of the United States should be picking justices. You've crossed the line of influence when that happens. So to say this is a democracy, when you do not have separation of powers between the executive branch and Congress, because they go over all these nominations, which they should, but in a different type of way, whereas it has nothing to do with any political party whatsoever. So I've got an issue with that, the way you're set up right away. Too much bias is possible from self-interest, depending on what side of the political spectrum you are. And this is an issue. And you had 250 years to get this right, and you still haven't got it right. Let's move on.
Roberts to get gone. Anyway, so let's take a look at this. This article is from CNN Politics. It'll be linked down in the description below. We're going to hit some of the hot spots. Also, I've got the opinion written by Clarence Thomas and, of course, Roberts' dissent. We're going to take a look at the first bit of that opinion just to get kind of a feel for what this case is about, because it's actually infuriating that this is a thing. And then that'll be linked down in the description below as well if you want to check them out, okay? So, Supreme Court over John Roberts' sole dissent rules in favor of student in First Amendment case. That's right. The Supreme Court, in an 8-1 decision, came down on the side of free speech. 8 justices, liberal, conservative alike, all shared one common understanding. This is a free speech issue, and the first...
Okay, so what's the issue? 8-1. So it's quite a convincing position, 8-1. So why do you have issue with one dissenting opinion? Why do you have issue with that? Why do you put that energy out there? Because putting that energy out there creates other issues. Is that the purpose of this? You just don't like the fact that it's not unanimous, and your ego has been battered, it feels hurt, and it needs to react and put energy out there to create a situation. I don't see it any other way. If you do, just post in the comments or chat, depending if it's the live chat, if it's after the fact comments.
First Amendment's pretty flipping clear, and this is a pretty obvious violation of the First Amendment. Only John Roberts doesn't think the court needs to address this, and it shows again, in light of several decisions lately, why I think his leadership needs to come to an end.
So he's making a case for why he thinks leadership at the Supreme Court should be changed. Now, are we just splitting hairs to satisfy an egoic mind? Let us go further into discovery here.
The Supreme Court on Monday revived a lawsuit brought by a former student seeking to hold his state university accountable for violating his First Amendment rights when it barred him from speaking about his religion and distributing religious literature. Okay, so let's take a look at this opinion real quick. We're just going to read the first bit of this intro from Clarence, from the court. The petitioners are former students of Georgia Gwinnett College who wish to exercise their religion by sharing their faith on campus while enrolled there. In 2016, this guy whose name I can't pronounce talked with interested students and handed out religious literature on campus grounds. He stopped after a campus police officer informed him that campus policy prohibited distributing written religious materials outside areas designated for that purpose. I mean, to me, we're already in a place where speech is being far, far too restricted.
I'm going to backtrack here just a titch. Now, he brings up Clarence Thomas. I really do not think Clarence Thomas is a de facto standard to measure everyone else on the bench by. That's just my personal opinion.
Look, I can get it if you don't want people distributing religious materials during class in a classroom. But on campus, generally, here, listen to this. A college official later explained that he could speak about his religion or distribute materials only in 2 designated speech areas on campus. This is not a private school. This is a state school. This is a state school. And even then, only after securing a permit. What? You need a permit at a state-run school to speak about religion, and you can do that only in 2 specific free speech zones. But wait, there's more. Campus policy at the time prohibited using the free speech zone to say anything that disturbs the peace or comfort of persons. It's not a free speech zone if it doesn't rankle people a little bit. It's not hard to permit speech that's happy. Of course, their faith, which is not really being stated here, it is stated elsewhere. These are evangelical Christians. This isn't some crazy out there fringe group of people. It's not like Westboro Baptists screaming about who God hates and all that stuff. It's evangelical Christians handing out literature, talking about their religion. And they're relegated to free speech zones. And then in those zones, they're not allowed to say anything that might make someone uncomfortable. Are we kidding yet? This is where speech is in America right now. This is where it is, and this is where
Yeah, there's no doubt about it. Free speech is very, very important. Just because somebody's opinion does not resonate with you does not give you the right to shut them down. Now, it will depend circumstantially upon the meat of what's being presented, but that's where I say but, it's all within reason. And differing viewpoints are very, very important. Otherwise, everything's going to be plain vanilla. Who wants plain vanilla? And plain vanilla is not most optimal to begin with. Let's see what Nick has to further say.
people, they think that that's freedom. It blows my mind every time. I'm sorry, I'm ranting about this a little too much. So Justice Clarence Thomas, writing for an 8-1 majority, allowed the lawsuit to continue.
Okay. Sorry, I had to stop because I want to comment while this is up on stream. Now, Justice Clarence Thomas, I'm not a fan of him. So he's writing the court's viewpoint here for the public. And Clarence Thomas allowed this lawsuit to go through or to be heard by court. He acquiesced on behalf of the court to allow it to go through. And Thomas wrote that it was undisputed that the individual's rights were violated and that he could proceed with the case even though he was only seeking nominal damages. Now, there was 8 for and 1 against. And the dissenting opinion was from Chief Justice John Roberts. In an unusual lone dissent, said he thought the dispute was now moot. Roberts stressed that the student had graduated and the challenged restrictions no longer exist. So, if we backtrack, second paragraph, Justice Clarence Thomas writing for an 8-1 majority, allowed the lawsuit to continue, even though the student, who has since graduated, so the student's no longer there, he's graduated, was only asking for $1 in damages, and the school's policy has changed. So this is very important. Guy's asking for $1 in damages, and the school's policy has already changed. So what's the point in all these resources costs a lot for the Supreme Court to gather and make opinions and statements in law. So the fact of the matter, the party that filed the lawsuit had since graduated, and the school's policy has changed, whereas this issue should not arise again in the future. So what's the point in going forward with it? So now, and I got to agree with Mr. Roberts here, and he states, if nominal damages can preserve a live controversy, then federal courts will be required to give advisory opinions whenever a plaintiff tacks on a request for $1. So he's using reason to equate all the factors from a financial and punitive point of view. So what's further stated here, on the surface, the case was about a dry legal issue concerning so-called nominal damages, awards which are issued when there is a legal wrong, but no actual financial loss occurred as a result of the wrong. But, and this but states, lurking beyond that issue was a fight brought by strange bedfellows. I'm not sure exactly who these strange bedfellows are, seeking to broaden the path forward to sue the government for First Amendment violations. So let's go back. Chief Justice John Roberts, in an unusual lone dissent, said he thought the dispute was now moot, no longer a point. So let's move on. Roberts stressed that the student had graduated and the challenged restrictions no longer exist. The school policy has changed. So he's right. Those challenges no longer exist. Now, I don't think that the top court in the land of the USA should be hearing it. Now, it'll be different if we see a pattern of this going back and forth. The school policy changes another way, back to the way it was, and then forward another way. Then I can see this going further after we've seen a pattern. But as far as we can tell here, there's no pattern that's been predetermined. So therefore, I agree. The restrictions that made this challenge a viable challenge just no longer exist. So it is a moot point. I just want to be clear about that. So let's move forward.
Continue, even though the student who has since graduated was only asking for $1 in damages and the school's policy has changed. Well, of course it has, right? It's amazing. These institutions infringe on rights, and once they get sued, they change the policy and say, oh, well, We didn't, it's not going to happen again. Of course, what's going to happen is a little bit of time will pass. They'll re-implement the policy and it'll be back. And then they'll change the policy again. And then, oh, well, shoot, that's a new school board or whatever. A new governing body came in and they, they just implemented that. We've removed it again. It's not going to happen again. And then a year's going to pass. Same thing's going to happen. They'll wait for the student to cycle out and they'll infringe the next person's right. This is a story of government over and over and over. We've seen it on the First and Second Amendment quite a bit recently. Saw it in that New York Second Amendment case where New York, once it got to...
Hold on. Over and over again? This is a state college. Yeah, a state university. A state university. Not a federal university. We're talking a state university. And furthermore, Mr. Rekieta, we got politicking that affects the state level in order to facilitate a political party leaning on the federal level. So your system and the framework is rife for allowing positions of self-interest to manipulate in such a manner that the minority voice is louder than the majority voice. So in a democracy, the majority prevails, and that's the sanctity of being a democracy, freedom. But your system is set up and the framework is set up in such a way that self-interest rules, whereas the minority can control the majority. So your democracy's got to be addressed. This is going to come out further in different conversations, different opinions in different areas as we move forward. I want to further stress, Nick, that I'm not a lawyer. And if anybody needs advice or misconstrues this as advice, do not. If you need advice, legal advice, seek out a lawyer. I'm not a lawyer. This is an opinion. It's an opinion piece. And we need this dialogue in order to provide for consensus that the majority agree to.
To the Supreme Court suddenly had a change of heart about the policy they said they were definitely going to enforce, and they're like, whoa, we're not going to do it anymore. And of course, the Supreme Court, including John Roberts, decided not to hear the case. This is the problem with Roberts. Moving on, Thomas wrote that it was undisputed that the rights were violated and that he could proceed with the case even though he's only seeking nominal damages. Chief Justice John Roberts, in an unusual lone dissent, said he thought the dispute was now moot. Roberts stressed the student had graduated and the challenge restrictions no longer exist. Quote, if nominal damages can preserve a live controversy, then federal courts will be required to give advisory opinions whenever a plaintiff tacks on a request for $1. So the idea about nominal damages is that this guy didn't suffer any economic harm. He didn't lose any money. He didn't lose any property. What he lost was far more important in some ways. It was his right to speak about his religion, something guaranteed.
Hold on. Hold on. Once the egregious act of First Amendment rights was addressed, it was corrected. So to think that, woe be me. This is the egoic part of the mind. The lawyers speak, etc., etc. Let's get back down to some basics here. Let's get more grounded, Nick. Let's not get carried away with the egoic mind and keep pounding a position that just puts energy in the wrong place. Every situation is different. And you ask 10 people that witness a car accident, they see the same thing, but you get 10 different versions. Okay? So to say this gentleman suffered or was hurt is a misnomer and should not be emphasized any further. And that's just my opinion. Like, this was short term, this was corrected, and to think that he suffered because of it, he did maybe for a short term. It was very frustrating, no doubt for him, but he shone a light on the fact that his rights had been infringed upon and suppressed, and it got corrected. So let's not friggin' beat the drum more than it has to.
In the First Amendment, and Roberts is like, I don't know how we're supposed to protect this. I don't know how the court's supposed to protect someone's First Amendment right. I mean, he didn't lose a laptop that we can reimburse him for. And he just lost his right to speak about his religion. Where's that even protected, bro? This man is an embarrassment to being a Chief Justice. So some of the other issues that are here are expressed by some of these analysts, and let's take a look at them. I think the most important thing about today's ruling is what it did not hold. For decades, civil litigants and especially civil rights plaintiffs have relied on the notion that alleging minimal damages is a sufficient way to get into court for claims of legal violations that may not have caused quantifiable economic injuries. I mean, this has been in place forever. And Roberts is like, nah, we don't want to do this. We want to get rid of civil rights claims that don't amount to actual economic injury. Do you understand like how ridiculous that is? Like, let's say you're a black person and you want to go in and buy a sandwich. Well, you're not suffering economic injury if you don't get to go in the store to buy a sandwich because you're black. But your civil rights have been violated. Let's say you're a Christian who wants to stand on a street corner. Right? You just want to talk about religion on a street corner, a park, or whatever. You want to calmly walk up to people or set up a little table and say, "Hey, let me just tell you about Jesus." And then someone comes by and says, "Nope, actually, you can't speak on public property about that." What economic harm have you suffered? None. But the government has restricted your freedom, your liberty to do that. And that's valuable. Just because there's not a quantifiable economic injury doesn't mean we shouldn't hear these cases. And the court has never thought that's true. The lower court's decision in this case, had it been affirmed, would have thrown that into serious jeopardy. But today's ruling reaffirms the viability of the approach and keeps courthouse doors open for those whose rights were violated in a way that may not have caused monetary harm. So here it says he's an evangelical Christian who was a student at Georgia Gwinnett College, was standing on a stool in a speech area at his school, talking about his religion and passing out religious literature. He'd followed the school's direction and reserved a spot designated by the school as a speech zone. Speech zones are offensive to the First Amendment. They're offensive to the basic notions of liberty, and I can't believe we're still stuck on this, but we are.
Yeah, you're still stuck on it. And the question you got to ask is, what? Only in America? The land of the true and free. And you still got issues with freedoms of rights. Suppression by the left, suppression by the right, you claim. You claim by the left, you claim by the right. Suppression, oppression. We get really caught up in this sense of duality, don't we? Now, Here's the question. I cut this off now. I'm not going to go any further into this. This is a very simple case to begin with. Very simple. Nothing sophisticated about this whatsoever. So the question here is now, do you think the duality of left and right is appropriate? Because everybody's in this camp. I'm in the left camp, I'm in the right camp, and my way is the only way, and vice versa. Now, and this is where you got a real big issue in the United States of America and in Congress, especially right now during this period in time. You do not allow for the left and the right to create dialogue back and forth to form a consensus that all sides agree upon. And this is a real issue. We've seen the stonewalling from both sides. And this is the issue. Why is it such an issue to have left and right opinions be expressed in order, and this is the part that's missing, the left and the right do not rise above and provide a general consensus. It's my way or no way. And we're supposed to be intelligent people. So there's something wrong here with that. So why do you have an issue with that in the United States? Why has, instead of in unity together we rise and fall, you're just creating more duality and a further divide between left and right with no possibility of a general consensus that serves the people in the best way it possibly can. So I'm going to finish with that. Any questions and comments, just put in chat. And otherwise, remember one thing. Your health is priceless. Stay safe. Stay healthy. Michael J. over and out. Take care, folks. Enjoy your day, night or evening.